Ladies and gentlemen, if everyone is ready, I think we can already slowly get started in a very timely fashion. I'd like to welcome you all. My name is Adam from EU40. We have developed a little bit of a sort of EU40, for those of you who don't know it, with a network of the young members of the European Parliament, and I think beautifully represented today by two members of Parliament. And Mr. Voss, you're clearly an honorary member, as you think young. And we developed a little bit of a new concept over the past months, and that I think came out of the frustration to have been very, very bored in many events, talking about very complex topics on a very superficial level. So I think that's something that we want to change a bit. We call it a four smarties concept, which differs in a way from the four dummies concept. So we have in this room, I think, everyone sitting at the table or around the table here, people who are working in one way or the other with the topic professionally. So I think that should give us an adequate level of debate. This debate is being web streamed, so we purposefully chose a small room with a round table. We would please ask everyone to please participate, and that means also people sitting on the red chairs and outside. Everyone's equal to this debate, irrespective if you have a name in front of you or not, or if you're at the table, or if you're sitting in the back. Help yourself to some tea and coffee while this goes on. So it's a kind of no respect rule, please. You know, we want this to be a tough debate. We want you to feel comfortable and take a drink in between. And this is actually the last thing that I'm going to say for today. So I will now hand over into the very professional hands of Magnus Franklin. And don't be fooled by his photo. He now has a beard in the meantime, but it's still the same person. And beards have been on Vogue for a while. I think it went out again, but I mean, never mind. And he's a journalist, chief correspondent, telecoms, media. So he really knows what he is talking about, definitely. And I'm looking forward to you moderating this debate. And that's the last you've heard of me. Thank you.
Thank you very much, Adam, for that introductory remark. I am indeed Magnus Franklin. I see a lot of familiar faces, but for those who don't know me, I'm a journalist at MLEX. I've been reporting on telecom, digital tech policy for about a good decade, or 9 years or so, mostly from this institution. So it's with a lot of excitement I want to get into this debate, and I think the format is very exciting. I think Adam set up very well in saying I would like you all to participate. It's a very interactive format. We want to really try to get to the bottom of things. We're not going to have big introductory remarks or position papers here. We're just going to have an effort to get to the heart of the matter. So I'm just here to make sure we don't have any fist fights and those kind of things. So with any luck, otherwise it'll be good web stream TV, I guess. But you're not here to listen to me. Let's bring it over to our hosts, our young MEPs, Jan-Philippe Albrecht and Axel Voss. Thank you very much for having me as well as moderator. I'll let you set the scene, and then I think we'll delve into some probing questions about the matter at hand. But maybe, Jan-Philippe, do you want to kick us off?
Okay. That's the order here with the young MEPs. Thank you very much for the opportunity here. I was pleased that there's such an early interest also in the EU40 group to highlight this as one of the major topics which we have to discuss with stakeholders and inside the Parliament together on an early stage. So I would absolutely underline that. I think that this is one of the more bigger files which we still have on the table in general in the European Parliament for this year, as my feeling is sometimes also that in the Commission, this Commission does not only follow the line that a better regulation seems to be no regulation, but in particular this year seems to not be very urgent, proposing new proposals before some elections have been passed, and also some new developments in the Brexit process have been passed. So nonetheless, I think that those things which are on the table, including in particular this regulation proposed by the Commission, from some urgency also, because if we see the surrounding in which this regulation and also the history in which this regulation appears, then first of all, this is not something new, but something which has to be renewed, and that is the e-privacy directive. And secondly, this is something which is not like disconnected from other things, but this is taking place in the course of the data protection reform, which we laid the foundation for last year with the data protection regulation, the GDPR in particular, but also other issues are in this area, like Police and Justice Directive, like also which is now proposed the regulation for the EU institutions. That all is linked together. And that means that, of course, if we set a date for the application of the GDPR on the 25th of May next year, then this also means for us that we shouldn't overlap too much with other parts which are interlinked with this framework. And this is in particular the case here because I don't know how to express that less lawyer linguistic, but it's lex specialis to the GDPR, the e-privacy directive, which means that it's not to be seen in parallel with the GDPR, but it is more or less to be seen together with the GDPR. So those who are processing personal data in the field of electronic communication, they do not only have to follow the e-privacy directive today, but they also have to follow the General Data Protection Directive, which will be replaced by the GDPR, which means that they have to follow also the GDPR in the future. And that could mean quite a lot of mess if we wouldn't propose a result on the e-privacy regulation before the application of the GDPR. Therefore, I see that we are in a somehow a time restraint here, which means that we have to start early, not that we have to cut off any process or any debate, which we still have to take. With regard to the substance, I think that the notion of the GDPR is that we have to bring in line the rules in this sector with the rules in the GDPR. That is important because we don't need to double, we don't need to do different rules if it's not necessary. But it's also clear that we have to regulate differently in certain areas. Why? Because the GDPR regulates data protection, while the e-privacy directive and the future regulation is not only based on the question of data protection measures in this sector, but in particular looking at the added requirements by the fundamental or human right to confidential communication. And that is still there, and it's also independently from data protection there, and it has its own implications, which in particular is with regard to devices which you use for communication, which is with regard also to services which you use for communication. And therefore, it's a very good step by the Commission that they are redefining the notion of what electronic communication means, in particular to say that communication today takes not only place on networks of telecommunication services, but also on other devices or networks or however you want to call it. That is also important seen from the companies because we wanted to achieve the single level playing field, not only inside the GDPR and inside all of those who fall in that scope of matter, but also in general in this field of data processing, especially personal data processing rules. So that means that we also have to create a level playing field between the different players in this scene, in particular when they are doing the same thing. And it doesn't make such a difference anymore if you do a call with your mobile phone provider or if you do that call with WhatsApp call or Skype or whatever. And this brings me perhaps already to some final remarks because I don't want to stall this and we will have plenty of time to discuss everything. That I think what the Commission has proposed has, first of all, two very important signs. First, it is a regulation which creates a level playing field in the European Union for this sector. That's important. It redefines electronic communication, which also creates a level playing field, but also brings legal certainty a bit more with regard to which rules to be applied in certain areas. And I think it also brings a continuity to what we decided in the GDPR on the level of protection of personal data, which is of course also an important issue, because there are consumers and citizens with the expectation that there is protection in place, in particular here where it is about tracking and so on. And but I would also say finally that there are things to be fixed still. I really think that with regard to privacy by design and by default, we need to make things right. And we should follow the standard which we want to implement here, especially when we want to build it on technical standards in the future, which I think would be good because it makes easier communication between consumers and controllers about their privacy settings. Then we need to be sure about what privacy by design and default means. Secondly, when it comes to how and for which purposes data can be used, I think that lowering of the standard of protection today, in particular in light of the various possibilities what you can do with tracking personal data, tracking individuals online with their devices, not only in the internet, but everywhere, wherever they are, with what they do, and so on and so on. I don't think that consumers would accept us lowering the level of protection, which means that we should also here make clear that if we harmonize the rules on data protection, which is beneficial for everyone, then we are not trying to do that on the back of consumers, but we take their concerns to utmost account and build a standard which is the highest possible in their view too. Thank you very much.
Thank you, Jan-Philippe. And for the rest of you, you won't be able to speak that long, apart from Mr. Voss, of course. I'll be cutting you off. But we'll have another scene setter from another excellent German MEP from the EPP party, Mr. Voss.
So, thanks a lot and welcome to all, and a special warm welcome to Laure Wagener. She was our counterpart 1 year ago when we negotiated the GDPR. So I very much appreciate that you are here. So now we are trying to bringing the additional law of GDPR environment in shape, or we are trying these, and yes, trust is important, yes, privacy is important, and yes, fundamental rights are important. But let me speak a little bit general here, but if we are approaching all new digital developments with the same attitude, although we are facing a digital revolution. With other words, if we don't see chances here in this ongoing digital development and seeing this only as a threat to privacy and fundamental rights, we won't win the game and the economic future, and also this not the satisfying security at the end. So GDPR, big data, e-privacy will otherwise end like it always does. So then it might be that we are overprotected, overburdened for the economy, overregulated our development, and the consequence would be what I already mentioned in another reception already, what we attended. Also, what Henry Ford once said, if you always do what you have always done, you will always get what you have always got. And this is what I would like to avoid in the future a little bit, and we should more realistically on how the citizens or the consumers are behaving, and what the digital revolution at the end means. So I never expected a kind of proposal like this for the e-privacy directive. My first thoughts has been always that we have done the GDPR, and what's left could go probably to the telecommunications code, and but this isn't the case now, and we have to deal with all these questions again, and I would say we are facing in the future a lot of déjà vus. What I have thought we have already done a lot of all these questions, like consent and everything what's surrounding these. But so I expected this, that we have always done a step beyond this situation. But so, but now we have the GDPR, the privacy proposal is, from my point of view, a little bit redundant, and what is left again can go to other regulations like the telecommunications code, and we have already said into the GDPR, in the GDPR, don't infringe fundamental rights of your customers or our citizens. And this is the headline for everything, and I'm not quite sure that we have to do this again and again in a way. So what I would like to have, or to see this at the end, there is no overlapping between the GDPR and e-privacy, and we should try to align both instruments, and personal data and sensitive data should be subject to the same rules. This is what I have in mind. So if I'm coming to the consent question, so now the e-privacy proposal says, oh, you need more than less a kind of a consent for kind of every processing of data. And this is, from my point of view, already contradicting the GDPR. It's absolutely not helpful to compete then, and it's endangering probably digital creativity. And if we are looking to the third-party cookies at the end, so technology based on these won't be possible probably any longer if we are having this in place. We will have a close look to all these and find out what is possible and what not. But we should be very cautious and here, and I don't want to see all lock-in models that they will be predominant models at the end. From my point of view, so there is no distinction in general any longer regarding anonymous data, pseudonymous data, and personal data. I think we should correct this also, and probably there is no understanding for the processing of data in a digital division of business. So, as you know, probably, not all of you probably, but I had already had my problems with the consent in the GDPR, and for me this is a kind of an old structure and the wrong answer to the digital revolution. If you rely on consent, my thesis is then you will give up at the end your whole privacy because of the consent. And I would say our citizens are not reading terms and conditions. Our citizens are consenting to everything what they would like to have or would like to use. And no one of us is probably understanding to what we are consenting at the end. So, and as another point in this proposal, I do not consider an e-privacy proposal as an lex specialis. For me, it's a kind of an addition of the GDPR and nothing else. And again, also here one sentence could have been enough. Don't infringe the privacy of your customers or our citizens, and keep confidentially. Is this right English? Yeah, but you know what I mean. So if it's coming to direct marketing, we all already have some referrals in the GDPR to it, and therefore I'm not quite sure if we need again here kind of a more deepened situation about this. And but the GDPR is the frame, and then we can have probably something around this. And just another general remark on this, we included in this, I think recital 32 it is, also political parties when it comes to direct marketing. So for me, again, selling democracy is not the same like marketing for a salami. So that's why I would see sometimes this not really included, but if we are weakening explicitly all the time our democracy, we shouldn't not be surprised when the democracy is a kind of a clearing sale product. So this is what I would say we should always be very careful if it's coming to the one pillar of the democracy, political parties. And what Jan already mentioned, I'm totally agree regarding the level playing field. At first, we should make sure that all modern communications should have the same level playing field like the old ones. And also we have to think about if we shouldn't create a level playing field also to these business models who are not communicating but also are using personal or sensitive data regarding the definition. So let's more face reality and let's be more encouraged to find better ways. Thank you.
Excellent, Mr. Voss. Thank you for that slightly different perspective. I thought politicians always agreed, but sometimes I'm wrong. So as a first session, we're going to have a panel of experts from many different points of view contributing. We have Laure Chapuis from the Cabinet of Vice President Andrus Ansip from the European Commission, Dr. Ian Walden, Professor of Information Law at Queen Mary University of London. We have Professor Nico Herting, a lawyer at Herting Lawyers, and we have Gwendol Legrand, Director of Technology at the French Data Protection Authority, CNIL. We have Cornelia Kutter, Digital Policy Director at Microsoft here, Jacob Grenier, Senior Manager European Affairs at Deutsche Telekom over there, and Frederik Zuiderven Borgesius from the University of Amsterdam, and Joe McNamee from European Digital Rights. So we have a good collection of people here. And instead of doing what panels usually do, which is just allow everyone an introductory remarks and so on, I think we'll just dive straight into the issues because I think they're all set out in the opening remarks. And I maybe start with a question to Cornelia, which is this issue about privacy by design and default. I think there were, in the run-up to the adoption of this regulation, there's a lot of discussion about whether privacy should be the default setting or an option or and whatnot. And in the end, we end up with a quite, well, what Joe might say later on, it would be a kind of weak option from a privacy point of view. Do you think that the Commission landed right on that particular point?
Oh, this is really going right in the middle of the debate. So I assume you're focusing here on Article 10 and the browser default setting, or the way, as we understand it, is a bit of a mix between do not track and tracking protection lists. What we understand, for us it is of course important that what we have to comply with is something that is suitable for our users, and you have to see that in this specific case the Commission has opted for a solution going away from the cookies, putting the pressure on the browsers for behavior that is triggered by websites. So the question is whether browsers shall become the policeman for the internet, and that is sort of a question that needs to be asked. it's clear that there has always been a race in that space in how to allow a business model that is driven by free services, and that is a discussion that is not core for our business, but we will, if the regulation would be adopted as is, which I don't think it will, we would need to implement that there. Experience tells that where browser settings are very strict, there will be a response from websites that earn their money by no, that's okay. By being based on advertising, and so I think the question is whether that is the right model. For us, it is important that we can actually comply with the requirements, and so that is something that still needs to be discussed. I think the discussion needs to be actually not set at the browser level, but on the website level and the advertising level.
Very good. Joe, sorry I mentioned you there in the introduction to Cornelia. Do you want to come in on that theme about the role of browsers and the privacy by design and default?
We have at the moment on a European level rules on criminal sanctions for unauthorized access to computer systems. And we have a proposal in Article 10 that the door may be left open on computer systems to be accessed or not, which would create a very peculiar dichotomy between the Attacks Against Computer Systems Directive and the Privacy Directive, with the Privacy Directive perversely offering less security and privacy. And when you look at what's happening with the market failure and the security disaster of Internet of Things at the moment, the notion of leaving the door open to end-user equipment is a very strange and disturbing one. Briefly on the websites based on advertising, the websites aren't based on advertising, they're based on harvesting data for third parties, generally speaking. And that's an important distinction, because if you are communicating directly with your customer as a news site, for example, then the reader is your customer. If you're harvesting personal data with third-party advertising, then it is the profiler and not the consumer who is the client in that business. And it also means that you have a very strong interest in not being transparent and not offering free and fair consent, which is one of the problems with the approach that Mr. Voss mentioned a moment ago.
Very good. I think we will continue that interesting discussion maybe from the regulator's point of view. Cornelia mentioned rules that a company like Microsoft can comply with. As someone who's going to enforce these rules eventually, Mr. Legrand, do you want to come in on this topic?
Yes, thank you. One fundamental aspect in the regulation in the proposal is the fact that consent for tracking on the internet is central in the proposal. This is fully in line with user empowerment, which is promoted in the context of the GDPR. Now, what the Commission has tried to do so far in the proposal is to define a scalable solution, because today when you go on a website, you see those banners, and if you continue browsing, basically your data is going to be collected by a number of third parties to do targeted advertising. So the intention was to empower the user in a scalable way by proposing solutions directly in the browser. There's two types of solutions that are implicitly mentioned in the regulation, as mentioned by Cornelia before. There's the express settings, more or less, for storage of cookies on your browser, and there's positive signals sent by your browser or by your device more generally, because it's not only browsers, to those that are going to do the profiling. What is not clear today is whether the two need to be configured by the user. So would an express setting in the way that you have, for instance, in Internet Explorer or this type of device, this type of software be sufficient, or do you also need to configure Do Not Track? That's one thing. And the second thing, the nice thing with Do Not Track is that it's scalable, so I can send it to a website, and if you're in a real-time bidding environment, it can send the information to all of those parties that are likely to collect your information and to target you. Now, what is not clear today in the proposal is whether this consent, which is expressed through the Do Not Track setting, can be bypassed by the website that would continue to display a banner, and if you continue browsing, then place the cookies on your device. If it's the case, then we're not reaching the objective. So the objective is really to empower the user, give the possibility through the browser or through the device to express your choice, and this choice has to be taken into account by basically with consent banners that would circumvent the user choice.
Very good. One of the lawyers and academics in the room want to come in on the Article 10 issue, who've been looking at it in particular. Mr. Wallen? Yeah.
I think from my perspective, one of the issues about whether these provisions should appear in the e-privacy directive, because these are rules governing the two ends of the communication. This is not about the confidentiality of the communication. This is about the relationship between the two ends of a communication. And I think that's not appropriate to put in this directive when this directive is based on Article 7 of the Charter, when it's to do with confidentiality of communications, and we have rules in other legislation such as the e-commerce directive about unsolicited communication. So I from a academic perspective, think having these rules governing this relationship between the two parties is not appropriate for this particular directive. So in that respect, I know, as was mentioned already, I mean, this is a sort of a hangover provision. Where it's most appropriate to put this, I think, is the GDPR.
Maybe, Laure, yeah, sure, I'll let you come in. But Laure, can you explain maybe what the thinking was behind this? Is it a hangover provision because it needed to have continuity from the current cookies regulation, or was it something that genuinely had a confidentiality element to it?
Well, first, I would like to come back on the purpose of all this, and clearly we wanted to make sure that the user is much more empowered, as you mentioned, and that's the whole reason why we have this semi-privacy by default. I would say we're almost there, but there is an element of an action of the person. I think that's where we have decided to come with this. For the two-side end users, well, it's quite clear. We wanted to implement the GDPR in a way that the consent needs to be given on both sides. You cannot just have the consent given from, especially when you come for the consent on the content of the communication. It's extremely important that the person that is also at the other end knows that the information is being used. So that's the reason for such a thing.
Mr. Harting, you wanted to come in as well?
Yes, I agree with Ian Walden. I think that the issues of online marketing covered by sections 8, 9, and 10 of the proposal have nothing to do at all with confidentiality. That is really the sort of center of the proposal. Online marketing has been discussed at length in connection with the GDPR. At the end, the GDPR does cover online identifiers, so it does cover all these issues here. So there are bound to be a lot of inconsistencies. The main inconsistency is that while the GDPR, in fact, does not at all center on consent. There's in this proposal, there is no real alternative to consent, which is completely inconsistent. We have the provisions in the GDPR that consent is invalid when there is the clear imbalance between the consumer and the company. We have the provision in the GDPR that consent is invalid when as far as data is concerned, that is not necessary for the performance of the contract. So consent is very, very weak under the GDPR. This is sort of leveled out by legitimate interests. That's the end of 5 years of discussions of the GDPR, and now we start from scratch with this directive or regulation proposal, and the whole discussion is focused on consent again. In connection with consent, there are sort of hidden questions. For example, the question, well, yes, the e-privacy regulation does cover not only natural persons, but also legal persons. But who is the person who gives consent? Well, it says the end user. And there's sort of a reference to this other directive that is under discussion, but it doesn't give you a clear answer. So, for example, take a big company like, well, from the news today, Peugeot, who equip thousands of their employees with devices. When it comes to consent, according to the EPD, is Peugeot is the sort of who at Peugeot is to give consent? Who is going to be asked? So I don't think this works, and it is completely inconsistent with the GDPR, and it is the big question is, do we really need this?
Frederik, I'll let you come in on Article 10.
Well, I agree with Mr. Harting and Mr. Walden that theoretically there's way more elegant ways of regulating spam and online tracking, etc. We could, for instance, do a separate direct marketing regulations and deal with everything, spam, phone calls, cookies, etc. But historically we have the GDPR now, and trying to redesign from scratch that, well, we can try that, or you guys can try that in 20 years again. But I think now pragmatism, we have the GDPR, but that is an omnibus regime with therefore somewhat open norms, which is a good system. But it makes complete sense to have for certain sectors more specific rules, drawing harder and clearer lines. So although academically, in theory, I agree the whole system could be designed better, I don't think this is the moment to start doing that. We have now a pretty reasonably good proposal for an e-privacy regulation, and now saying, yeah, but spam doctrinally doesn't fit in there, and Wi-Fi tracking and tracking cookies doctrinally shouldn't be in this regulation. Well, I guess I agree, but somewhat, but I think we should do that discussion for the next review of the whole system in 15 or 20 years.
Very good. I think that helps, I think, set the scene. And I want to apologize as well. Jakob Kreiner from Deutsche Telekom, I don't think I properly introduced you. I mean, this issue of Article 10 isn't necessarily directly a telecom related issue, but does Deutsche Telekom have a perspective on this, which is not necessarily about the communications part of the privacy directive?
Well, we certainly have a perspective on consent, because it has been named now many times, and I want to jump into that, because the goal of the Commission is empowerment, user empowerment. And when we're looking at the data processing article in the sector-specific piece, we wonder what the justification is to introduce quite strict rules for telecom operators to process metadata compared to the GDPR. And in the GDPR, what they have come up with as a solution that we find is actually a perfect balance between, on the one hand, safeguarding data privacy, and on the other hand, also giving companies the possibility to innovate, is the possibility to further process data even without a second legal base or without consent, as long as the new purpose is considered compatible with the initial one. What does that mean? That means that a company needs to do a test, and in that test we need to take into account the nature of the data, the circumstances, the consequences for the data, and I think that is important, whether we have applied appropriate safeguards to secure the data, for example, pseudonymization. Now, when you look at this proposal here, you see none of that in here. There is no incentive given to apply appropriate safeguards. There are no exceptions from consent given, and we find that a bit unfortunate, given that even the Working Party 29, 1 year ago, in the opinion on the e-privacy revision, has proposed exactly that. They said there could be exceptions from consent as long as there is little or no risk for the individual given. And on that sense, we would like to see a little bit more flexibility when it comes to processing metadata, as long as we're securing the privacy of the individual. And just to jump in on one specific problem that we see in this Article 6 of the proposal introduces in a way 2 phases. The first phase is we need to first of all check whether we can achieve the purpose we want to achieve fully anonymized. And only if that test fails, we come to the second phase, which is, all right, let's move on with personal data, but we need the consent of the individual. Now imagine Deutsche Telekom says we want to, I don't know, for example, propose a solution on infrastructure optimization. And we believe, and this is actually taken up in the proposal, that if we want to do infrastructure optimization, we need identifiers to, in a way, look at a stream of people, and combining location and time. And for that, we need identifiers, which means we need personal data. So this test has failed. We move on to the consent, and we get the consent from the consumer. Now imagine the Data Protection Authority comes back to us and says, Deutsche Telekom, you could have achieved this purpose with fully anonymized data. What happens then with the consent of the individual? The individual has given consent to the data processing, and the DPA afterwards says, you should have not even asked for the consent. So there are some questions in terms of empowerment where we think maybe there are also some solutions besides consent in this regulation that we should maybe pursue.
Okay. Fredrik, you want to bounce back on that? You had a thought?
Yes, meanwhile, I was thinking more about, do we need these specific rules for online tracking, etc. And then I realized the 2002 e-privacy directive had a regime for third-party cookies, which resembled very much the legitimate interest grounds. Basically, it was a system, set them, and offer people an opt-out. But then we saw, after 7 years, that this whole industry got bigger and bigger and relied on that opt-out clause and didn't tell anybody anything. So then 2009, the reaction of the European Commission was, well, actually, this apparently doesn't work because they do this completely in secret, unlike the directive requires. We make it an opt-in system, still not ideal, everybody agrees, but at least there's now some transparency. So the last few weeks I've heard a lot of people saying, well, 6 legal bases, like in the GDPR, is better, but there's a very strong risk that you end up in the 2002 situation, namely all this stuff happening in secret and not even a pop-up banner.
Okay. Loch, you want to come in on that as well?
Yeah, I just wanted to pinpoint that where we are coming from, and I mean, you mentioned the 2009. I think we are coming from a system where the providers are actually not allowed to process freely. It's a bit more complicated under the E-Directive, except for the services, the functioning of the services. And that's where we, and I come back to your comment earlier on, Mr. Albrecht, that we are opening the door for further processing, and that's where we wanted to add the safeguard of the consent. And why did we take the consent and not the full range of possibilities under GDPR? Well, because the legitimate interest is not just a blank check. There is a lot of additional safeguard in case of sensitive data. And in the field of communication and all the content, but also metadata, we are there in a field where we cannot separate what is personal, what is not, what is sensitive, what is not sensitive. It will mean, in order to find out what is actually the sensitiveness of the data, to go into all the different points. And that's where we have decided to go for such a strict type of element. I then agree that the consent can be then another opening of further type of abuse, but then it's for the implementation to make sure, I would say, that everything is well implemented. We have looked, and we have looked into this possibility of enlarging, because we have had some sympathy, of course, on this front as well. But it's true that it became difficult to actually use the pseudonymization as a way, even with the Article 29's opinion, where there they made the distinction between sensitive and non-sensitive data. That's why we...
I'll let Cornelia come in, and then Mr. Hatting.
Yeah, based on that, I think I can see where the Commission is coming from in looking at network-based electronic communication services and the restrictions under the former e-privacy directive. When you look at how electronic communication these days function, I think the change in technology and in the use of those technologies by citizens is that they use electronic communication services much more than just a letter carrier, but it's really part of their personal assistance. So the limitations that have been created will make a number of features that currently are expected by users very difficult to process. To give you some examples, spam seems to be only possible with the respective consent of the spammer. Skype Translator is a processing of data in transit. A person that does not hear well will have to make that hearing disability known to any other participant of a conference call in order to use voice-to-text technology and so on and so forth. So the list of features and technology improvements for citizens is long, and the basic approach that has been taken is that consent is the only mean by doing this, while legitimate interest of a service provider has not been regarded in its overall approach, because when you look at the GDPR, legitimate interest is not something that a service provider can only claim, but within the legitimate interest, there's actually a balance of fundamental rights to be done. So only if it does not inhibit the fundamental right of the user can a company claim the legitimate interest of a person. So again, just to go back to the point on, it is more than only a letter carrier, which has been the source and the fundamentals of the beginnings of the e-privacy. And so there is obviously some adaptation to be made for the traditional electronic communication services, but what we ended up with is a restriction of features that users really want to have. And so there's also an imbalance of potentially other fundamental rights of people not to disclose their disabilities. So it is quite complex, and I think it requires us to really go into the different scenarios and how they are covered to approach this in a different way. And one last point that I wanted to make here is if this is really not an overlap with the General Data Protection Regulation, but it is only a different fundamental right, and then we should probably really make very clear that what we are covering here is communication only in transit. So that is something which apparently is meant by the Commission, but it is not entirely clear that this is really the case.
Great. We have a long list of interveners piling up. So, Mr. Hatting, do you want to take us further?
Thank you. I disagree with Frederick. We don't need the EPD for transparency, because we have all these long transparency provisions and fines and everything in the GDPR, and I don't think anybody doubts that they apply to online marketing as well. So for transparency, there is no need for extra regulation. I agree with Cornelia. Well, first of all, it should be clearer as it is if the EPD only covers communication in transit or not. Indeed, if you look at 6 subsection 3 and letter B, and you translate that into sort of plain words, that means you have to ask the spammer for consent when you put spam software in there. I mean, this can't be serious. And then maybe it might be worth to sort of put the things into perspective. This is about the EPD is necessary. It's about the protection of confidentiality of communication, which we are talking about wiretapping and surveillance here. This is what the EPD is about. And why does everybody talk about online marketing all the time? Is this really sort of the main problem that we have here, yeah, especially with the GDPR already in place? I think it is well worth looking much more at the provisions that protect confidentiality. It is necessary to discuss if there is probably well, I don't know if it's an unwanted side effect of what was discussed under the caption of level playing field and the OTTs. You put the OTTs under the EPD and they all have to provide backdoors according to Article 11's subsection 2. I think this is something that needs to be. I think this is a much more far-reaching consequences than some of the other issues that are discussed in connection with the cookies. The online marketing is the backbone of how commercial internet works, as we all know. There are issues, as we all know. They were discussed at length in connection with the GDPR, but I think it might be worth putting the things a little bit in perspective and not sort of starting to think that this is the sort of these issues are far more serious than issues of wiretapping and surveillance that the EPD is centrally covering.
Thank you very much. We're getting into some really meaty discussions here. Joe, you're not immune to wiretapping either, so I'll bring you in, and then we'll go over there. And then I think Jan-Philippe wanted to say something as well. So, Joe, please.
Just generally on the previous comments, I think I'm going to sign up enthusiastically to one thing that Mr. Voss said, and that is if you always do what you've always done, you'll always get what you've always got. And what we've got is the level of distrust that has been illustrated quite clearly in the Eurobarometer report on the e-privacy rules. And most particularly, I strongly recommend looking at the US government study from last year from the NTIA, which found that 45% of people had not engaged in online activities, in specific online activities in the previous 12 months because of fears about security and privacy. That level of distrust is exactly what your report in 2011 on the data protection reform said that we need to avoid. I agree with what you said today. I agreed with what you said now. There are a few bits in the middle that I may disagree with. The way things have been shaped up to now has meant, as I described the market earlier, you have the individual, you have the company that's collecting the data, and you have the third-party tracker. If the third-party tracker is your client, then your innovation is designed around them. And the innovation around providing data to third-party trackers is amazing. There are millions of real-time auctions about how your data should be sold, how your eyes should be sold every moment of every day. Innovation as regards transparency and consent and easy-to-use information. The lack of innovation in the most innovative industry that our society knows is absolutely amazing. And it's because there's no drive, because the user just isn't the center of the market. And that's exactly what Laura was saying. What what Laura was saying, that by moving the center of the market to the individual, you move the innovation towards the individual, you increase trust, and you increase both protection of fundamental rights and the market for new and innovative services. Article 11, there's a problem. Article 11 is the illegitimate child of Article 15 of the existing directive. Article 15 of the existing directive is the most magnificently bad piece of drafting that the world has ever seen. And before the UK leaves the EU, I'd like to say thank you to the UK for giving us that. Article 15 was designed to facilitate untargeted data retention, and through its various transformations has ended up becoming the thing that is defending us from untargeted data retention. How can one text manage to go through the whole gamut of absolutely being needed to allow something and absolutely being needed to prevent that very same thing? Article 15 was a political statement by the UK with some help from Uncle George at the time. We need to avoid at all costs that any amendment to Article 11 ends up being another political statement, a political statement against encryption or unreasonable processing of personal data. It should be narrowed to everything that's not covered by Article 23 of the GDPR. And as befitting a regulation, it needs to be much more precise in order to prevent the kind of abuse that we've seen over and over again from the member states. And I'm prepared to work with everyone to try to achieve that aim. And I'll stop talking now.
Thanks, Joe. I guess one type of innovation costs money and the other one makes money, so maybe that's the explanation there. Now, Jean-Philippe, I know you're really itching to go. There was one, Mr. Legrand. Do you want to keep it brief?
Yeah, very quickly. We've been talking about confidentiality of communications and confidentiality integrity of the terminal in a way. So whether you can place cookies or read information from the device and whether or not the communication itself is confidential. This is the follow-up, I would say, of Article 5 of the current e-privacy directive. You had 5.1, which was confidentiality of the communication, and 5.3, which was the cookie law, which has evolved, as was explained before, because in 2002 you had this opt-out rule for placing cookies. In 2009, the legislator said, well, there's more and more targeted advertising in the internet, on the internet. We need to put the user at the center. We need to empower the user. So we're going to do information and prior consent. Now, what happened afterwards is you had all these banners and things like that. So the intention was to give more control to the user, and the banners in a way were preventing the user from giving an efficient consent. And in the meanwhile, there's been more and more stakeholders appearing on the market. So now you have tons of stakeholders in the real-time bidding industry. So what is important today is not to go back. So the principle is good. Principle of information and prior consent, 453 for the targeting on the internet is good and has to be preserved. And what the Commission has tried to do, according to the reading that we do of the regulation, and this is also what was proposed by the Article 29 Working Party in the opinion in July last year, was to propose some technical solutions, innovative technical solutions, to empower the user to find something that is scalable, to find something that is technology neutral. So we're not just talking about cookies, which is placing some information on your terminal. We also think about fingerprinting, where a device is going to read information sent by your browser, by your terminal, and create some kind of unique identifier based on non-unique identifiers sent by your device. We also think about the mobile applications that you have on your terminals. We need to keep all of this in mind when we design the solution. The solution to send a signal, once again, from your browser, which is controlled by the user, is very good in principle. If the consent, if the configuration of this terminal can be easily understood and this is also one point that has been raised before. So you need to understand what you consent to, but with signals such as something similar to do not track, where when you install the browser, you say, well, this is what I accept, this is what I refuse, this is scalable, easy to understand for the users, and if it's correctly implemented, it can reach the goal to empower the user and facilitate the good development of the internet.
And Mr. Walden, I'm just going to let you hold for a second, but Jan-Philippe, you've been itching to come into the debate, so please.
Yeah, just to perhaps step at one moment on Article 11 once more before we are leaving to the other things again, because I think that you are absolutely right, both of you, on Article 11, that this is not what we should go for. We should be more concrete in the future. The problem is here that it's not only the UK who has proposed Article 15 of the e-privacy directive, and which was going around and around. It was needed back then to get the European Court of Justice having a say on this area, because otherwise there would not have been a law, which makes it even funnier that the UK proposed, because without it they wouldn't have the ECJ judging on their laws, which also is even more funny because the court just ignored that the UK opted out of the Charter, which is for reason. But at the end, it's very important, I think, to say that this regulation proposal, although this article is very bad, does not impose backdoors. It's very clear that this wording does not do that, and it should not do that, of course, because as in the same way the GDPR is not imposing data processing or access rights for law enforcement, because this is in the hands of the member states, they should be held responsible also in this case for which rules they will adopt in this area. And this is an open discussion which we will going to have, but it will not be solved here. That's clear. That also would be clear because of the legal base. Which needs to be then law enforcement if you talk about access to these systems. Just to say that, but it's a huge debate which is important, and I think that this article is in this light not the best one, but perhaps we have to solve it somewhere else. Then just one general sentence on the debate which we had before. I'm very happy to hear that everybody is so happy with the GDPR and wants to be in the scope of it and wants to follow the rules and so on. I think that it shows quite a lot, but let's pass the more anecdotal debate here. Still, Article 7 of the Charter is there, which means also that it has to mean something. So we have to be clear that we couldn't just say, okay, let's just only go for the GDPR. It's just not possible. There is Article 7, you need to deal with this, and the question is right to ask, okay, what is it that we deal with? I agree that we have to talk about that. But still, metadata in communication, still devices and the integrity, as Mr. Legrand has said, of devices is linked to this fundamental right. And if this is the regulation which is also regulating this question, then we also have to follow what courts have said on that. And for example, not only the ECJ but also Strasbourg and national constitutional courts have said quite a lot on this. And it could not just be put away and then let's say this data can be treated the same way as every other data. And that also means that in this regard, I think consenting to metadata tracking and so on needs to be treated a bit different than in the GDPR. But also with practical reasons on consent, I think that we should not deal with the idea of what consent is until the GDPR, but we have to deal with what consent is from the GDPR, where I completely agree with Mr. Herting also, but also because I think that consent has been strengthened and also made better and meaningful with the GDPR again, with Article 7, also the various recitals, also Article 12 on transparency in general. I think that makes a difference, which also makes it perhaps more easy to build on that and make clear how consent in this sensitive area can work.
Mr. Voss, do you want to come in at the midterm, or do you want to save it to the closing? Okay, very good. We have more people, and also in about, let's say, 5-10 minutes, I'll take other questions as well, not just from our named panelists. So feel free to work on your questions as well or comments. But Mr. Walden, you've been waiting patiently.
Thank you. First of all, I'd obviously like to be put on record as saying that I'm not happy with the GDPR. However, one of my first comment was I thought the way in which the e-privacy directive deals with this relationship between the communicating parties, it's not appropriate for this directive, and it's not just a matter of it's here. You know what I mean. The second relationship which the Privacy Directive deals with is this relationship between the state and the user. And I just thoroughly agree with Joe's comment that Article 11 is just completely inappropriate. It's neither too small nor too big to really address these issues. And I think, as we know, the whole question of law enforcement access, the whole question of balancing across a whole range of law enforcement needs, both on a national and a cross-border level, means we need to address this outside of this measure. So my second, plea would be to say, let's, reduce Article 11 to the minimum necessary to hand over to a much more appropriate instrument.
Please, Cornelia.
And building on what Ian is just saying, there is a complex relationship between the e-privacy, law enforcement rules and telecommunication rules, and I just want to point out that in the Electronic Communication Code, which we are in parallel discussing, the way the Commission has proposed to include more services into the overall obligations of the Electronic Communication Code is based on numbers. And so just to point out, there is, instead of a network-based and network-independent distinction, they have used numbers, which is questionable because they will disappear, but they also include one-way number-based services in there, which is Skype Out, for example. So in that context, a very small feature, not more than 0.5% of monthly user base, 3% of Skype users in Europe use that. But for those, we would have, under the Electronic Communication Code, an obligation to register and thereby might be subject to intercept capability obligations. So just to point to that backdoor link and how these issues are pulled together. Now, from a law enforcement perspective, I don't think there's anything gained by having 3% of one communication app covered by it, but at least if that remains as is, also think about that those network independent apps are not working because they don't own a network in each country, so they are per se not established in those countries. So I think we should remember that the e-privacy regulation is a digital single market directive aimed at harmonizing the digital single market. So if something like that remains in the e-privacy, at least we need to have some recitals pointing back to mutual legal assistance tools such as the European Investigation Order or any other mutual legal assistance agreement that might apply to it, so that network independent apps can actually function cross-border. Otherwise, we risk that they will disappear.
Very good. Actually, Cornelia, while I have you on the line, I mean, where would you draw the line? I mean, shouldn't we as consumers expect to have confidentiality of communications on, WhatsApp, Skype, all these online tools that we use?
No, absolutely. I mean, the point here is not that confidential of communication shouldn't apply to communication services. The point here was that there might be indirect consequences to that specific Article 11 that we need to consider and just make it right.
We had a comment over here, and then I'll go to you, Mr. Walden. Please, Mr. Kreiner.
But just to jump back to Jan-Philipp Albrecht's comments on metadata, that it cannot be treated like any other data, I would like to at least try to contest that a little bit. In that sense that what in 2002, when we started to get regulated as the telecom sector, indeed, telecoms infrastructure could be considered critical, and also the handling of such data. But if you look at 2017, I would rather say this applies to almost every service offered over the internet. And you can take exactly, but you can also take the banking sector, for example, or insurance data, and I would say there's also a criticality to that. And coming to the scope, I mean, we're talking about level playing field here, which means a new definition of electronic communication services. But as far as I understand the Commission, you are arguing to have stricter provisions on data processing remaining because metadata is considered sensitive. And I'm going to quote you because this is something that the Commission is repeating all together, and I think it relates to also jurisdiction, that you're saying that location information, location data, in particular if stored over time, may allow very precise conclusions to be drawn concerning the private lives of individuals, their whereabouts, and so on and so forth. Then at least I would like to try to understand why in the scope of this Article 6, the only ones who are regulated are electronic communication services. Take, for example, a mapping app, which is not considered an electronic communication service. GPS is far more precise than a mast, a telephone mast that we're having in order to enable the communication with somebody. And then I would like to hear an argument why, and I can understand this is a sector-specific piece of legislation, but if you're arguing with the sensitivity of location data, I don't see a difference between one from the other.
Okay, all our academics are lining up to comment, but Laure, do you want to reply on that specific point?
Well, there is one, is that you can actually turn off your app of location in your mobile, and you cannot really turn off your location from the communication side.
And you're sure there's no location-based service being processed if you're turning off your location-based services? I'm just gonna...
Voila. We'll continue that discussion. Mr. Walden, and then we'll run through this direction.
Just one comment following about the legal certainty created by this new concept of interpersonal communication services. As well as my academic hat, I'm also a solicitor and of Counsellor Baker McKenzie, and I must say I earn a very good salary just talking to companies about whether a service is mainly about the conveyance of signals or whether it is not mainly. And I think I'll continue to earn money describing whether something is functionally equivalent to a communication service or is not functionally equivalent to a service. Now, obviously, law is inevitably vague, but trying to push a level playing field coupled with this idea that every manifestation, every minor ancillary feature falls within the scope of the directive, I think ends up in where the gentleman from Deutsche Telekom says, why don't we just actually have some rules that apply across the board? If location data is highly sensitive, let's have rules on location data. Whether it's generated in the context, and we know how wonderful that phrase in the context has generated lots of litigation under the 95/46 directive, is just going to create uncertainty, and their uncertainty just doesn't protect either individual data subjects, and uncertainty certainly doesn't help the industry provide innovative services.
Okay, Mr. Herting, do you want to jump in as well?
Article 6 covers both metadata that you were talking about and communication content. And I think one very, very important aspect that has not yet been mentioned needs our attention, because I think that is one of the major flaws of the draft. Article 5, in its old version, in the directive, offered protection against wiretapping and against surveillance. The new proposal suddenly offers protection against wiretapping, surveillance, and data processing. And I think that is a very problematic concept, because data processing is what you need for communication, and wiretapping and surveillance is what you want to protect communication from. And I think we'd better be careful that we don't end up with a directive that that protects us from communication rather than protecting our communication. And I just think that it is a mistake to treat the content of communication in Article 6 as something that is as dangerous as wiretapping and as surveillance.
Well, Frederick, you wanted to comment as well?
Yes, if the chair allows me, I was actually wanted to slightly change the topic to...
Okay, well, should we go back to Mr. Legrand then? Because I think you want to reply on this and
Oh, yeah.
we'll go to you. Yeah.
Yeah, very quickly, just a comment on the functionally equivalent. Sometimes I have the impression we're making simple things very complex. When we're talking about functionally equivalent services, we're just talking about the fact that you have a smartphone in your pocket and that with your smartphone you're sending SMS, but you're also sending instant messaging, using instant messaging services. You'll have these. And the expectation of the user is the same with respect to your telco, in terms of confidentiality, or with respect to the functionally equivalent service, which is the messaging application. So that's what the proposal is about. This is what the Article 29 had proposed in the opinion in last July, last summer. This is what we're talking about. So for SMS or equivalent to SMS, or voice over IP, or video over the internet, you have the same device, you're using a service to communicate with another person, you want the same protection, whether you're using your telco or whether you're using a messaging app, full stop.
So Frederick is going to change the subject. Before he does, no, that's fine, but raise a show of hands who wants to jump in, comment, questions. Okay, usual suspect. Okay, do you want to change the subject and then we'll, yeah. Okay, so we have plenty of more comments to come. So, Frederick, please.
Slightly change the topic. Earlier we discussed sensitivity of location data, and that triggered for me Article 8.2b, which I'm worried about. If a pessimistic or cynical reading of that basically says, or you could read it as tracking people's location through their Wi-Fi signals or Bluetooth is allowed as long as you put on a poster which says, if you don't want us to track us, put off your Wi-Fi and your Bluetooth. I find that problematic. So it's not even an opt-out system. It is worse for individuals than a legitimate interest grounds. However, I think I understand some of the reasoning behind it, because you can do useful stuff. Imagine a large concert somewhere or a large festival. I can imagine that with Wi-Fi signals you can see where the crowds are too large. And if you would always require consent in a shop, it would be doable perhaps, but not on a festival or next to the highway. So I think you could have your cake and eat it too by saying it should be opt-in, or immediately anonymize and aggregate, so that you can still do the useful crowd management stuff, but you're not following people with a poster as a fake opt-out in their daily life.
Cornelia, you wanted to come in on that?
Yeah, I just want to respond to the functional equivalence, and sorry that I'm hopping back. It's just this, and actually it's based on a reading of a paper that Frederick wrote. When you think about what you are protecting, so we have this, you can think about the sector-specific regulation now, because the sector is bigger, it's still sectoral. But what I think Quendel wants to protect is the value and the communication of it, and so it doesn't really matter whether or not you're functionally equivalent. And we have seen that from a regulatory perspective, that it can be a false parameter in the electronic communication code. For example, the business models are very, very different. So in some cases you need the protection, and in other cases you don't, depending on the underlying business model. So I think we need to be very, very careful in how we use this. If the protection is based on the communication as such, I think we come to different conclusions than if we just compare the functional equivalence of a specific service.
Anyone want to come in, either reply to that or to Frederick's point about tracking crowds in stadium? Monsieur Legrand, yeah.
Very quick comment on the Wi-Fi tracking. Yeah, it seems that the current proposal allows for Wi-Fi tracking in public spaces if you just have an information sign saying, yes, you're entering in a zone that is being Wi-Fi tracked, and could be potentially a very big zone, by the way. So then if you boil this up to let's say 3 solutions, you have the consent solution, which is can be difficult to obtain in some cases if you want to consent to the Wi-Fi tracking. Solution right now in the proposal is to switch off your Wi-Fi. My Wi-Fi, I probably use my Wi-Fi for other purposes than being tracked. This is why I have a Wi-Fi, is to communicate. So if I switch it off, then I won't be able to communicate anymore. So I guess from a user's perspective, it's not very satisfactory, not very efficient if you want to promote the use of high-speed internet and networks. And then there's other solutions which combine probably pseudonymization when you collect the data, a very quick anonymization, probably limits on the sizes of the areas that you're going to monitor, limits on the retention periods, and probably a solution to opt out, maybe a standardized solution to opt out to the Wi-Fi tracking using your device. So you can also find innovative technical solutions to allow for the development of Wi-Fi tracking in a way that protects privacy. The solution, which is right now in the proposal, to just have an information and tell you to switch off your Wi-Fi if you want to opt out, is not very satisfactory. It's quite similar, I mean, to switching off your GSM if you don't want to have some data collected.
Now, Joe McNamee has been quiet for far too long in my experience, so it's, I think you want to come in on this, and then we'll go to James.
Just briefly to agree with what Gwyndwel just said, it's actually a perfect example of the point that I was raising before about the need to protect citizens and business at the same time. Because if you have a situation where your Wi-Fi, your Bluetooth is open to guerrilla attack at any moment because you didn't see a sign that was on a wall. And I'd love to get some UK statistics about the number of parking tickets that are overturned every year because the sign on the wall wasn't clear enough. It seems to be a permanent battle to have signs that are clear enough to be legally acceptable. Once you start giving people reasons to not use electronic communication services, once you remove their freedom of choice, it's not just the citizen, but it's also the associated businesses that lose.
Thanks, Joe. Now, James Waterworth from CCIA. If you can have a comment as well, or if it's a question, just say who it's for.
Thank you. It's a comment, if that's okay. I just want to throw out there a contestation of the idea that this is any more a lex specialis. I think it's fairly obvious. Historically, 20 years ago, if you were regulating the communication sector, the number of players in that was extremely limited to a few players who were probably putting hardware in the ground or something akin to that. I think, particularly given that this proposal brings a massive extension of the scope of companies covered by it and touches upon, if I name a few, the marketing sector, the communication sector, the dating sector, the tourism sector, and all kinds of software which can be adapted to allow the performance of communications. I would argue we can no longer call this a lex specialis. This is extremely general. So I'm not saying, for some people will think that's a good thing, and some people will say that's a bad thing. and that's a matter for debate. But I think it's extremely important to be clear that we are regulating a huge number of sectors, and software is very different from hardware, where hardware required someone to go and dig up a road to put something in there and a lot of money. Software can be, of course, deployed in a matter of hours, and so a service, a platform, a piece of software, an application can be adapted within minutes or hours to perform a new function, and maybe didn't have a communications feature and now does. So this proposal where an ancillary feature performing communications brings in a lot of players is extremely important to understand. And I think this question of functional equivalence is not as simple as was portrayed by my colleague to the left a few minutes ago. Comparing a piece of software with the standardized SMS is much more complex than might otherwise seductively be portrayed. Many peer-to-peer software applications allow not just the sending of a message in a textual format, but of course videos or money or e-commerce or all kinds of new features. So how we will decide whether a particular application is functionally equivalent is anything but simple, and it will be necessary for the law either to say that this only applies to things which are in a form of text communication, or to take out many of these things which are clearly not functionally equivalent. So I'm afraid it's an extremely complex thing and not something which is similar. And I think we should probably abandon the whole idea of functional equivalence because software changes so rapidly. Thank you.
Thank you for that comment, James. Can I pick on Laure maybe to explain again what the Commission was thinking in putting this forward? And I think it echoes some of the comments from before, saying, are we just catching up on things we wanted to get done in GDPR, but that were subsequently removed in the negotiations, and now we're trying to reinsert them back into their key?
Well, first I will comment on the lex specialis. I think, yes, it is true that it is, first, we have many provisions that are similar or at least refer to GDPR. So GDPR is our socle or our basis, that's clear. Now we go much further, but why? Not because we wanted to catch up lots of things that were in or not in GDPR, but because the way communication has evolved over the years is tremendous, and we didn't want to leave anything out. And that's our position. We had worked on the code, on the telecommunication code at the same time, and tried to align. They also extended to OTTs and to equivalent services. So that's the reason why we are having this broadened scope. First, we wanted to. It was a conscious choice to make all kind of communication. Then, yes, it is difficult to see what. When it would be a communication purely or not, or what is ancillary in there. But the reality is that if we don't cover those kind of communication as well, we know how things evolve. They will just take this open door and start increasing. So that's also the reason why we then added from the code these ancillary services.
Anyone else want to come in on this question of whether we're in a lex specialis or lex generalis situation? Yeah, please.
Well, it can only be partly lex specialis because it covers legal persons. There's consumer protection in Articles 12 that we haven't talked at all about today. So the sort of very academic question, if it's lex specialis or not, is only a question, as far as I can see, in connection with Articles 8, 9, 10, whereas the rest covers issues that are clearly not covered by the GDPR because they are either don't relate to data protection and or are consumer protection issues and issues in connection with the confidentiality of communication, which has always been regarded as a telecom issue. By the way, the protection of devices against cookies was originally viewed as a means to protect the device. That is the logic behind, that is the logic why it got in the 2002 directive. In 2002, there was the notion that the device had to be protected against software that was installed on the device. That was the logic of the 2002 directive. And that is the reason why nobody even discussed whether this was about natural persons, legal persons, or anything data protection related. Because this rule, the 2002 rule, was to protect the device. So I think this is important to bear in mind when, especially in connection with comments that I've heard today that, well, we've always had this in this e-privacy directive, and so we'd better keep it in. Yes, we've always had it, but it had a completely different focus than the focus that we are discussing it in now, where we're discussing it as a provision to protect the privacy of citizens, including legal persons, but where we don't really know which persons to turn to. Is it the sort of CEO of Siemens, or is it the sort of all his staff running around with the Siemens devices, and so on?
Mr. Voss, I'll give you a word a second. I'll just turn to Mr. Greiner for a comment.
Two small remarks on something that we've seen also in this proposal that we find rather critical. One is there's a recital in there, and first of all, we welcome that this is a regulation if it's going to come into force. But what we see in there is a recital that allows member states to specify what is written in this regulation. And I think a lot of you here in this room are already seeing at the moment what happens with the GDPR and the national specialization of some rules in the GDPR. For a company like Deutsche Telekom, which has several subsidiaries across Europe, it's a nightmare to have to deal after regulation once again with maybe 8-9 different national laws that might deviate from what has been decided in this regulation. One more point, because in the beginning it was said that we have to try to align with the GDPR, and if we have deviations from it, it needs to be really, really necessary and justified. There is an article, it's Article 9.3. Article 9 basically references the GDPR, says if you have given your consent, you can withdraw your consent at any given time. That's nothing new, and this is referenced here. But Article 9.3 imposes on companies who fall under this scope an extra information obligation, a notification towards consumers to every 6 months in periodic intervals inform the consumer exactly about this right. Basically, hello, if you have forgotten, you can withdraw your consent at any time. I have not seen so far in the impact assessment any justification on that. Deutsche Telekom might be able to deal with something like this. It would mean that every day an email goes out to a customer saying, by the way, you're a customer now since 6 months, you can withdraw your consent. But imagine a smaller enterprise doing so. So I think just naming this example, we really have to look at each and every article here and see whether really some deviations, some stricter rules are justified or not. In terms of transparency and information obligations, I think we have a lot already in the GDPR, and I would question an obligation like that.
Mr. Voss, was it specifically on this? Or?
Oh, sorry. Yeah, I would like to come back to the understanding of lex specialis in this case. So from my point of view, I would say, oh yes, we have a kind of a general rule created, and lex specialis means for me a little bit, oh, I don't care what the general rule is. We are doing here just a kind of a totally other thing because it's lex specialis. This is what I would say lex specialis. I don't want to have a lex specialis around the GDPR at the end. I would like to have an add-on, what we have left probably, and so the leftovers and then addition, but building on the ground what we have already agreed on and nothing else. And so this is what I would say we should come forward with instead of turning everything upside down again what we have already in place. So this is why I would like to see, this is my interpretation of lex specialis at the end, so that you are not binded by something what you have already in place. And I don't want to see this at the end. I would like to have a kind of a development so that we have something as a basic instrument and then seeing what we can add on, but not turning this in a wrong direction.
Thank you, Mr. Voss. And you can elaborate soon enough in your concluding remarks. Cornelia.
Yeah, I just thought there's one article we haven't yet mentioned, so I'm going to mention it, which is Article 7, which again is a deviation of what we know as the deletion principle, and which again brings us back to why would that specifically needed for that data compared to any other sectoral data, and why can't we just live with the general data protection regulation in that fact. And my understanding, but I hope Laura might actually give some justifications for Article 7, in particular paragraph 1, is that it is drafted from an old understanding of how telephone works, and where you would eventually with your telephone not expect the communication to be stored other than for educational purposes, as we often are reminded of when calling service centers. But communication these days just works differently. In most cases, you would expect that data to stay very, very long time somewhere in the cloud. So it again is for us not entirely clear what the objective here is, and why that is not the same as general data protection regulation, why we need this specific provision.
Thanks. Joe, please.
Well, I guess one of the reasons is 6.3 that refers to the processing of communications data, which is not necessarily personal data, and therefore deletion rules would be required.
I guess, Laura, the question was kind of aimed at you. Do you want to give an explainer?
Yes, I would also say that it's much larger than just personal data. So, of course, the General Data Protection Reform regulation cannot be the only source. Then there is also all the needs for some providers like the telecoms, that they need for billing purposes to have certain data available for a certain time, and so that's opening those possibilities for those sectors. So yes, there is a strong telecom component behind, but happy to look more into the details of that.
You satisfied, Cornelia? Yeah.
Satisfied that Laura will look into this.
Not so much.
Very good. Does anyone else want to come in on this issue about Article 7 deletion? And okay. No, I guess you can resolve it bilaterally. We have about 10 minutes left of the Q&A. Any questions from the floor again? We have Mike. Oh, yes, in the back. Yeah, please. Just grab a mic because we're web streamed. So if you just grab a mic and lean over somewhere so that... and say who you are and what question.
Thank you very much. My name is Michael Neuber. I'm from the German Association of the Digital Economy, BBDW, and I just have two remarks. First, on the question of trust, there was this percentage stated that so many people distrust web services, and they would refrain from using web services because they are distrusting the integrity of the web. I do wonder where this distrust comes from. It certainly doesn't come from the ability of private companies to secure their data and protect the data of the consumers. I think we would all agree that this distrust comes from the fear that governmental surveillance plays a role in how this data is used and by whom. So I do not think, and I do not share the vision that the motivation for this regulation should be a distrust of consumers in private enterprises. And the second is on the privacy by design approach. I think it needs to be a legal assessment of what is privacy by design rather than a technical one. The legal assessment that had been pointed out here would be to balance the rights of the companies to perform the business and also the right of the user to have his or her rights protected. So a balanced approach is not only privacy by consent, as it is always promoted here, but it's also what was just mentioned here and what has been discussed for years with the GDPR is a balanced approach with having safeguards in place like pseudonymization or hashing or encryption. And on the other hand, opportunity to process data without any consent, but give the opportunity to opt out of the data processing and give enough and transparent information. And I think this is totally ignored by this regulation. And the second, by the draft. And the third thing that we as a digital economy are very worried about, this very one-size-fits-all approach does not only cover electronic communications, even where it is web-based, it covers the web by trying to regulate electronic communications, which may also be web-based. By doing that in Article 8, 9, and 10, we see in Article 10 a technical approach to how consent should be achieved and who should be prevented from accessing the device. It states that third parties shall be prevented from accessing the device. There's no definition of a third party. If you look at Article 8 and who would be permitted to set a cookie, which is only first party for their own services requested by the user, which is the most narrow exception for placing a cookie, then the question is, if you don't do it yourself, but have someone do it for you because you don't have the resources technically or personally, then the question is, who is third party then? Because third party in a technical environment is everyone else but the one who hosts the URL. So even if I have someone doing it for me and it comes from a different URL, then it's a third party. If Article 10 says to me it has to be prevented from accessing, then I couldn't even perform my service, even though I would be allowed to according to Article 8.1. So there are lots of, I think, inconsistencies, and the biggest fear is that it's over-regulating the web, and it's totally inconsistent with the GDPR, as we have, I think, a very balanced approach there in Article 6. Thank you.
Thank you. And if you just turn off the mic. Yeah, thank you. Joe, you were waving your hand, so I'll take you first.
I think that a lot of that comment was directed at something I said before. So the study was carried out by the US agency NTIA. They found that, if I remember correctly, and forgive me if I'm not correct, but the study found that 19% of people said that they or members of their household had identified a data breach problem of some description in the previous 12 months. So that would be a private issue. Of course, when you have the President of the United States wondering about the quality of the oversight of their surveillance, you do have to wonder. On that is also undermining trust. I said it before, but I'll repeat it. Going from 2002 until now, the level of innovation in terms of the ability of these innovative companies, amazingly innovative companies, to communicate in a transparent, meaningful, understandable way to consumers, compared with what they're doing with their amazing profiling, data collection, real-time auctions, is the divergence is enormous. And I would just and I just would recommend you to do something as an experiment. Next time you go to a cookie banner, click on more information, read that more information, then look at the cookies that were placed, go to the websites of the cookie placers, read what those cookie companies are selling to their clients, and you go from, I was going to say damn all information, but that would be a little bit rude here, very little information on the side of the consumer, and vast, fascinating insights into what your data can be sold for when you look at the cookie company's website. That's not balanced, and if industry really won't jump, then pushing is another option.
Just quickly, very, very quickly, because we're talking about the regulation here that should be a lex specialis to the GDPR, it's all covered by the GDPR. It's based on the controller's behavior and the information and transparency he has to give. So there is no need for third-party and first-party differentiation, but it's all dependent on who controls the data processing. So if I look at the GDPR, there are vast regulation on how I should give the information, how transparent I have to be, and who is with me on the on the website. And this will actually, I think, answer the question as to who informs who.
This man is like a machine gun. We'll have you as we'll have you on one of our panels next time. I promise. We soon will have to wrap up, I'm afraid.
Once we get the extensive information about what precisely you're going to change in your business practices, that makes all of this redundant, the quicker we can have another conversation.
Thank you. Mr. Legrand, you want to come in as well?
Maybe just a technical clarification, because it's quite interesting to see that there is some confusion about the wording in Article 10.1 when we talk about third party, because I believe that the intention of the Commission, once again, if you see where we come from 2009, where you were empowering the user, saying I want to be informed and give my prior consent to tracking on the internet. It's not the same thing as the first party and third party cookies. First party and third party cookies are technical things. When I go on the website will place, if this website is placing the cookie on my device, it's going to be a first party cookie. If the website is displaying a banner that is actually served by someone else than the website, then this is a third-party cookie. The meaning of third party in the article is really anyone who is not the user. So the idea, once again, is to empower the user and give the user practical tools to control who is profiling him on the internet. I think this is worth mentioning, and it has probably to be clarified in the so we avoid this type of misunderstanding. Maybe just to come back to what was said previously on the content of communication, I think the proposal recognizes that analysis of the content of communication is high-risk processing. This is an acknowledgement of the recent Watson ruling by the ECJ also. And there's a requirement in some cases to do a data protection impact assessment when you do some further processing of some information. It would probably be useful to have specific requirements with respect to this if you have, of course, the appropriate safeguards in place, which is also to publish this DPIA so that all the interested stakeholders have access to the information concerning the safeguards that are put in place when there is further processing of the data.
Thank you very much. We've run out of time, unfortunately. I could continue for a while longer. Before we give the floor to our MEPs, Laure, is there anything you want to rebut or clarify, or something that's been horribly distorted in this discussion?
No, I think we're fine. We will, I'm sure, have lots of other occasions to discuss certain of these aspects on the cookies. That's clear. And the third parties, first party, clearly we will have these occasions. I didn't came in on the Article 11. I think everything was said. I would say, but our intention there was. No, I wouldn't talk about our intention. I think what we have now on the table is a court case. It's very clear. We have a text that is maybe not so clear, but provide the possibility to have such case, and I think it's now up to the interinstitutional negotiation to see how far they want to go. But on our side, it was intentional not to go far, because it is not the place to introduce all the other elements. But I would come on something that you said, Cornelia. This text is under the digital single market. Yes, but it existed before the digital single market overall, I would say. So it's not because now we have set into priorities that it doesn't have to deal with certain law enforcement aspects. But it should be, there are proper provision for the law enforcement, and it should be in this context that it's looked into.
Thank you very much. Now, for the concluding remarks and maybe summarizing the debate a bit, Mr. Voss, do you want to? Igor, there you go.
Thank you. So, just to come back to the question of trust. So, sometimes I'm wondering about what we are talking about. If we are looking to all the users using 98% Google or using Facebook, and are we really sure that they are all have this deep trust that we are expecting our users or our citizens would like to have? We as a legislator should have the responsibility to see the whole picture, and from my point of view, again, personal data, sensitive data shouldn't be treated differently in this world, and they should follow the same rules at the end. When it comes to location data, again, I wouldn't say we shouldn't treat this differently. I don't see the need for it. And the business models are so diverse, so we should be more creative as a legislator and not under the motto what was good in the 80s is as good as today, for today. And so probably under this motto you can say the one-horse open sleigh might be enough. Why developing a car? And so I would say, so pseudonymized data, encryption might be a kind of a way to deal with and to be more creative. And I would demand a kind that we find solutions that give also SMEs or startups a chance, and not all only the big ones that can meet the requirements.
Thank you, Mr. Voss, for those reflections. Jan-Philippe, do you want to share your thoughts?
Thank you very much. First of all, I'd like to say that I'm really happy that we have such a lively debate on this substance, and so many things pop up that we also all have to learn from different perspectives first, especially we who have to deal with the proposal of the Commission from now on. Then I'd like to just generally say once more, I think that this discussion about is it lex specialis, should it be not, or whatever, is a more technical, like legal question. At the end, the thing is quite clear, and that makes it perhaps easier to deal with it. We are talking about the question in how far there should be rules which are diverting from the GDPR, but still dealing with personal data, so rules from the GDPR for this sector of electronic communication. And why and which are the points which we have to rule out differently. And I think that most of us agree that there are some certain provisions which have to be dealt differently than in the GDPR. And so we have to talk about the question, what in this regulation needs to be regulated, diverting from the GDPR, and how. And I think that seen from the user's perspective, seen from the public opinion also, and I think that should be the view of everyone, electronic communications, personal data should be treated more sensitive than any other personal data in general. Of course, there could be other personal data like political party affiliation or religious beliefs or something which by good reason is therefore sensitive data in the GDPR, but in general we would see that as like there should be additional safeguards. Now we talk about the question, what can that be? And in particular in this area of consenting, in this area, especially when it is something happening on your device, something's put on your device, there is reason that there is higher sensitivity, also because it's the protection of the device, but also because it is linked to communication. And it's a different if location data is linked to my communications or if it's linked to something else which might not reveal so many things about my beliefs, my life, and so on. Of course, that doesn't mean that other areas of location data being processed can also not be sensitive. I mean, but at the end, it was not seen as sensitive data as we wanted it to be, to just say some points out of the GDPR debate, but that's how it is. Then, with regard to how are we approaching this discussion, I think that it is needed that we all somehow come a bit closer to finding a solution, and to also see that the Commission is not stupid about everything is very important, because on the one side ask for the case that it shouldn't be one size fits all, but on the other side ask why aren't we not all in the GDPR is somehow a contradiction. So we should somehow approach it a bit more calmly, where a one-size-fit-all approach is suitable, and where we should have additional standards to be followed. And to, at the same time, ask for technical neutral rules, but on the other side say that there shouldn't be vague legal terms is also a contradiction. You have to have sometimes also legal terms which allow you to adjust certain laws and provisions in the future to new technologies. And therefore, we should also have a more calm approach on this question on the scope. And so therefore, I think that today's debate brought up quite a lot of points which we still need to discuss, but it also showed that we still want to follow this track, basically, which the Commission puts forward, that there is a regulation which foresees diverting provisions to the GDPR, and in addition foresees some other points which are not data protection. Yeah, but that's clear. And if this is now in the e-privacy framework or in the telecommunications framework, I can say that we have so many laws where things are not really suited in the right law, but sometimes politics are different than just like logical ways of doing laws. That's just it. But that also means that we have to be a bit pragmatic on if we want to come forward. And I think harmonizing the rules also here in this area is a benefit for everyone, and that should be seen also.
Thank you both for those final thoughts, and I think it's very candid and nice of you, Jan-Philippe, to hear that politics and pragmatism rule this house, at least. I think that's correct. I think we have a lot of basis for discussion. We got to some I think, quite concrete points of disagreement, but also some areas where we can maybe hammer out some compromise. So I think it was a very useful exercise. I'm happy to say it was web streamed. Some of the other e-privacy discussions were web streamed, but then removed. So let's hope that this confidentiality of communications issue doesn't arise with this one. But with that, I'd like to thank everyone involved very much in the traditional manner, and to Adam.
Well, yes, absolutely. Thank you very, very much to all the debaters. I very much feel that this was a successful debate because it was highly interesting, even for a layman like myself. So I learned a lot just now. And by the way that the articles were quoted out of the, coming out of it, you could hear that everyone really knows what he's talking about. So out of my point of view, at least. So really, thank you very, very much. A special thanks to Alessio Pisano, who reminds me a little bit like of one-man bands. If you have the drums and the tambourine and so on in the back, who's been facilitating and doing the web streaming and allowing that also to happen as not a behind closed doors event, but something that everyone can view. Also view after, of course, so not only live, but after be available. We will not take it offline. It's going to stay there. I don't know if you have to click any cookies when doing so. Alessio will be doing some interviews now with all of you who have debated. Ideally, we're going to make a small best of movie also of what we did today. So if you want to be on the movie with an interview, it'd be very nice if you could just hang around for a few more minutes and let Alessio take your interviews. This goes especially, of course, for the two MEPs in the room. I know you have to rush, but maybe we can take you on first and then the other respective speakers. Thank you very much all. Bye.